Hi, everybody.
Say
I
hi,
am,
everybody, too.
yes, we are so excited to have you join today. So, fun fact, y'all know me. I like to space people out, and sometimes you will only see a pretty face on here like once a year. And Michael was a long time follower and attendee of the webinar series, reached out to me, and he wowed me, which is kind of hard to do sometimes. And he was on the webinar series and he did such an incredible presentation. Y'all provided such amazing feedback that I had to book him again. And so we are so excited. I love a speaker who's going to provide you with fantastic information that is going to help you to grow your business, make more money. And you know, when we talk about getting you paid the money you deserve, well, that just makes my heart skip a beat. So, for those of you who are not familiar with this lovely gentleman, he is an attorney who specializes in personal injury. He is the founder and president of Medical Lien Recovery, which has helped medical providers optimize their compensation from a patient's personal injury lawyer. Music to my ears. He's been on a mission to champion the rights of chiropractors who accept liens and personal injury matters, and he is here to share his wealth of information with you today. Thank you so much, Michael, for being here today.
Thank you, Christine. I'm a sucker for a Southern accent, so there you go. But to all you out there, give you a little bit of background on myself. I was admitted to the California bar back in 1987, and my beginning parts was as an insurance defense attorney representing doctors, hospitals, and medical malpractice, as well as PI defense. Then I moved into business litigation, was a partner in a big national law firm, really got into the contract side. Then I had this entrepreneurial calling, and I had a business in the dot-com boom and bust, but I really found that I loved doing more of the contractual work I was doing, and I became doing a lot of advising for businesses on efficiencies and operations, as well as continuing the legal practice. And one day, a chiropractor came to me and asked me to help them with this thing called liens and, getting paid back in 2012. And I couldn't believe how much he was getting taken advantage of by the attorney, and got him fully paid on the first 5 matters, and he was shocked. His jaw dropped. And then from that, I ran, something's going on. Is there really a need for this? And I was just shocked at there was nobody that focuses just on this area, that the providers just weren't understanding that they were getting taken advantage of all the time or not knowing what to do about it. So what Medical Lien Recovery has really done is we champion as an outsource, first of all, representing providers in California, in person. But we also have this online portal, the MLR portal, which is meant to be national to help everybody do it themselves. And we're growing that. So in the end, the idea is doing business better in personal injury. And that ties into today. Because today, really, when we talk about liens and lien agreements, it's a contract. And the contract is the basis of really most all businesses. And this is your foundation in PI. So let me kind of go to share, excuse me, putting on so I can see, but my screen, and have this come up. Okay, come. That must be this way. Okay, sorry about that as I get this going. Okay, we're on. So as we get into first kind of a lien and law overview for you all, a lien really is, it's a voluntary written agreement between the parties. It is a contract. So when someone says you're on lien, it's a medical provider who's agreeing to wait to be paid. And by the way, that doesn't mean you agree to get paid less, but agrees you do wait to be paid to the resolution of the matter. It's kind of akin to a promissory note. If you lend someone money, then at some point, you're going to get paid back. And that's really what this is. So lien laws vary state by state. Whatever state you're in, a lot of states are governed by contract law, and that's like California. Some states use a letter of protection, which again is another lien agreement. I just consider letter of protections kind of like a light beer or a really watered down cocktail. They don't have any of the punch and none of the flavor, and it doesn't do you what you really want. And then some states do require you as a provider for, if you do have then that written lien agreement, to actually record it or to give notice of that lien in a public filing. So depending upon what state, your law is going to vary about what you do with the lien. Or what you do. Excuse me. So the lien is signed by the attorney and the patient, and this is what gets you leverage. And what's really key, and I always point out, and if you listen to my past presentation, The Ethics of Personal Injury, I really get into a lot of the attorney fouls that I did with Christy here and for Chiro Health, and it's in their library. But the most important person signing this lien, it's not the patient. The patient will always owe you your fees because you gave them the service. It's like saying, cut my lawn, I'll pay you $20. You don't sign anything, they cut your lawn, you owe them $20. The important thing is the attorney signing, because in many of the states, it triggers fiduciary duties by the attorney upon you. And a fiduciary duty is the highest duty by law that someone gives to someone else. So what they have at that point is a duty to their own client and then a duty to you. And when those duties conflict, they have to do things that still doesn't hurt you. So where you don't have the attorney sign the lien, they are often free to just send all your money right over to the patient when the patient says, I'll pay the doctor, wink, wink. So you don't want that. As I said before, agreeing to a lien does not mean you agree to being paying less. Now, in some states out there, you guys are part of common fund states. We aren't in California, but you have a law which will protect the patient from ensuring they get a certain percentage of the settlement resolution. But what a lot of the attorneys don't tell you is, while that means you may be getting less from the settlement and not enough to pay your bill, in almost all of those states, the patient still owes the remaining balance. So that is leverage in which the attorneys want you to still agree on what the total amount is owed so that it can conclude it for the patient. Now, not all lien agreements are the same, and that's part of what we're here out today. Now, I will say this. A lien agreement is better than having no lien agreement signed by the attorney. But most lien agreements are barely serviceable. When I first did this back in 2012 and started, every single client I had to redo in great depth their lien agreements. And I got so tired of it, I just created my own lien agreement. And that was actually published by Chiropractic Economics back in 2013. But most, what you'll find is that a lot of the lien agreements, while they generally don't harm you, some of them do by their wording. But most of what you want in the wording of a lien, it's how you get positioned, the specificity you need. The clarity of wording matters because this is something which the patient's being obligated to do. That's their contract. And then the attorney is in support of that with their own duties. But I want you to think of lien contracts like technology. They evolve by trial and error in technology so that it does better what we're designed to do. So that's why even on a lien agreement, I have modified this every year to make it better as I come across new tricks or things that attorneys are trying to do. So even if you've got one of my older liens, you should get the newer one that's on the portal and certainly be checking every year to see what's better because things do change and it is made better. So as I was referencing, you can get the actual lien agreement we're going to talk about today. Just get it at the MLR portal. It's all free to providers. It's a free course for 30 minutes. There's other resources to help you. And it's just about you doing business better in personal injury. We're here to help. So let's get into a medical lien agreement. Excuse me. This is the beginning of the document. So what I'm going to have for you on all the next slides is you're going to see what is the actual wording in the agreement. And then below it where I have those little red arrows, that's just a description I'm giving you about that. So that when you review this later, you want to go back and watch the presentation or you print out this, you'll be able to then reference what we've been talking about and give you the bottom lines. So like anything else, you have an intro paragraph. There's going to be 2 slides, 2 parts to this. The first is because there's key terms that are used throughout and that have great meanings in personal injury. Of course, the agreement, the patient, you as the provider. There's the incident, which is the accident, the attorney, proceeds, and of course, the PI litigation itself. So when you have, especially like a multidiscipline office, your office may be not just doing chiropractic. You may have acupuncture, physical therapy, maybe you've got a pain management person in there. So you're going to want to, and why you see the wording up at the top saying, including all entities specialists providing services for or through provider. That's going to then cover you if you are practicing under that entity name. If not, then make sure you have a lien signed by each entity. Okay, the next intro paragraph is really laying out so there's a clear understanding at the beginning what this is all about. So it's saying that this establishes a debtor-creditor contractual relationship. The difference is the attorney and the patient are in a contingency arrangement based upon the outcome of the case. That's not you guys. You don't want a patient thinking that, nor the attorney wanting to assert that. So you're laying out here. And it says where you're agreeing to wait to be paid. Now, even your agreeing to wait to be paid is still contingent upon them complying with the rest of the terms and provisions in this agreement. And one of the important things you see here is that saying upon breach of the agreement, you at your own discretion can file a lawsuit, meaning you don't have to wait for the 2, 3, 4 years, whatever it's taking them to finish the case. You can go and seek to get paid now, because when you wait, time is money. There may be bigger problems, but that's in your decision on what to do with your relationship with the attorney and your relationship with the patient. So now we're going to go into some of the individual paragraphs that go into certain topics. At the top, I give kind of a summary of what that paragraph is talking about, and some of these slides may be a portion of that paragraph because I wanted to break it out. So the first one, proceeds. This is the money. This is what you're entitled to claim from. This is a much more expansive definition of proceeds than most liens have. And MLR actually has a one-page lien also, where it's got a very short provision because we had to fit it on one page. This lien is 2 pages. But here you're looking at where it's talking about all the things that might come. Because in PI litigation, you're finding that it's not just really that main complaint. In fact, it might not be no complaint. It might have been off of just the claim off of demand. There may be cross complaints. There could be attachment proceeding. You could have arbitration, mediation. This could go to interpleader, or there could be an appeal. So what you want to do is to cover all aspects, no matter what happens. Your right to get paid comes out of whatever arises from that accident. And you'll note some of the key things: uninsured motorist, underinsured motorist, MedPay, and you may be in a PIP state. So you had proceeds. That's about the settlement. Now let's talk about your bill. What I've seen too much is just saying, okay, to pay the bill. But what is the bill? And what we've seen more and more things going on is, as attorneys require more work by you, like they require you to try to go get updated with the court, or they need you to go through so many hoops and spend so much time and money, you aren't generally recovering that on your bill. Well, this is changing that, or at least it's giving you the ability to. So you'll see providers' charges are saying full fees for all goods and services rendered to provider by provider to patient, including without limit, and then listing things. What you'll see that I highlighted later is even no-show charges. What I really want to point you to, and it's something new I added this year that wasn't on before, which is any related additional costs incurred by provider, including staff and doctor time at hourly rates, spent post-treatment to follow up on the PI litigation status and or payment. And I threw in here also an expert and witness fees. You'll find a trick that's done a lot is when they want to have you as an as an expert, and in most states, if they are going to have you for deposition or for trial, unless you're actually reading your notes, you're actually entitled to be paid as an expert. But they want to do that separately. And what you'll find that a lot of attorneys, if it's on the plaintiff side, will do is they'll say they pay you, but they don't. And then they say that's not attached to the lien. So we're trying to clear that up. So again, just realize that charges you want it. It's nice and overly broad. The idea is transparency, and you simply want to be paid for your time, and that time can grow. One thing I note in the comments, by the way, below, you may be entitled to something and all these charges. I'm not saying to say you have to get paid all of that. Again, based on your relationship with the attorney, with the patient, everything's on a case-by-case basis. You decide what to do, but at least you want to have the ability, if you're really getting put through the woodshed by somebody, to be able to assert what you've got to assert. Contracts are for protections in the event of the what-ifs, and you get a lot of what-ifs in PI. Now, something that this is more important, if anything, to the insurer, the third-party insurer, is that you're granted an assignment of all benefits, to the patient, and in the PI litigation, that assignment of benefits is something you can assert to that third-party insurer when they're going to resolve the matter. In fact, if you give them notice of your lien, and I recommend you even send them a copy of your lien, you find out who the adjuster is, send them a copy, make sure they've got a copy of your bill, note the assignment, and I would make a request of the third-party insurer to pay you directly. And if they're not going to follow that directive, that at minimum, they put your name on the check for the amount of your bill to whoever it's going to. That's going to further protect you. A lot of attorneys won't follow that, but at least you can. You can also, depending upon your state, let's say you have a matter that there's no no attorney. You can have a separate assignment of benefits. It's a much more expansive document, and you can have that signed by the patient and even recorded in your state. And it actually puts security interest, and that can protect you even more. So there are more things you can do, but we're noting here the minimal for your lien. Here's something I always find is really important, and I remind attorneys who seek to lowball all the time because they want to assert, hey, you're in this with us. We're all on the contingency train together. No, we're not. You're on the contingency train. We are simply agreeing to wait to be paid, and hopefully you're going to do your job really well. There's plenty of money to pay everybody, including us. So here it is clearly saying the patient owes the full charges regardless of the outcome of the PI litigation. So if the attorney drops the patient, they owe the full bill. They get defense to trial, the patient owes the full bill. Or if they don't get enough in settlement, the patient still owes the full bill. But of course, notice the next line, it's saying the provider may consider a lien reduction, but it's on a case-by-case basis. The important thing here in that next line where it says no lien reduction is agreed to in advance and no lien reduction should be assumed, you have attorneys which literally say, hey, oh man, that provider agreed on every matter I send them to only take 50% of their bill. Whenever you hear that, you need to run from that attorney or right away deny that, because if you've agreed to that before taking a case and you send your bill in full to the attorney to send to the insurance company, you just committed medical billing fraud because your bill is not what it means. If you agree to always do 50% reduction, which I know you don't, it's what the attorneys want to assert. So throw that back out them. You're not going to do illegal referral fee agreements, illegal kickbacks. That's exactly what they're getting into. So stay out of that. One of the things that you'll also find is, as a side note, when you assert your bill to get paid 100%, the really good attorneys want you to do that. Why? They want you to do it because the difficulty that they have dealing with insurance attorneys and adjusters is, again, saying your bill isn't what it means. So if you are getting paid 100% all the time or a lot and seeking 100%, that means when you go to testify at deposition or they go to assert your bill, you are a far more credible practitioner and you're going to actually get more business in personal injury, not less, because the matters that do go farther, yours is more bulletproof in terms of your bill, and you've proven it. Next is reductions before settling and in writing. Again, it's okay to do reductions, but please do it after, do it at some point, again, after you finish treatment. What you always want to have that it's in a writing signed by you. When they say it's an oral agreement, of all the people that should never be doing oral agreements, it's attorneys. If it's not in writing, it doesn't exist. That should be the way it works throughout life, I tell you, because people will deny they had conversations. They'll come up with something different. They might even be honest about their recollection, but over time, other things have come in that has changed that recollection. So here you're making sure that it's in writing. The next thing you put is that you want to make sure that and talk with both the patient, by the way, at your first visit, and talk to the attorney. Hey, I'm willing to consider lien reductions, but please come to me before my patient signs off on a non-policy limit settlement. Because if it's not policy limits, that means the patient has a choice. Do they settle? Do they try? And to know that choice, they want to know, do they have any additional potential personal financial exposure? And that's dependent upon your lien. So when you find these attorneys come to you after the case is already settled, and to make that settlement work, it had to have lien reductions, and now they're asking you, they are pitting you against your own patient. They're going to go to your patient and say, man, that provider, everybody reduces. He's just not cooperating. They could have easily asked before the case settled, right before, as they do after. So you really want to make sure that you're making that clear to the patient. You don't mind trying to help them, but you want to do it with full transparency and to make sure and a great way to ensure that Tell your patient, listen, if your attorney's asserted that I've reduced my lien, and I may have, but ask me, and I'll let you know if I have or I haven't. So you're going to know before you sign on the dotted line whether or not what you're being told is true. More on that same paragraph is what you'll find, and I found a lot, was that providers would agree to a lien reduction. Here, the attorney says, we've got a settlement of $9,000. Here's what I'd like you to do. Is that okay? And you say, okay. But you haven't heard from them in 4 months. Suddenly after, they send you your check for what you agreed to. What they didn't tell you is they got another $4,000. You should have gotten more money, but they didn't come back to you and tell you because you gave them an out. In your acceptance, you didn't have anything probably about how long that lasts for or that it was based upon that settlement amount. So here you're putting, attorney shall immediately notify provider if undisclosed additional proceeds become later available. Makes sense. And then it talks about increasing the payment to you. And if they're not going to do it, you've got that ability to void that prior lien reduction. Again, about full transparency and having you in control. So let's get into prompt payments or starting over. This gets into what I referred to is when you make an agreement, you need a timeline in which you're going to be paid. I literally get clients that have shown me that the attorneys and said, hey, they agreed a year ago. That was a year ago. Think of all the additional cost and expenses that it took for the office following up for the next year, but they want to hold them to that. So here I've tried to address it by saying, here's a timeline in here, but I definitely recommend you still do it whenever you agree to something, aside from what's in here, but this is going to be a catch-all for you. There's also partial payment tricks. Come on. You've all got this. You've got suddenly you get a check in the mail with a cover letter. And it says, this will confirm our agreement that you've accepted $1,000 on your $3,000 bill. When you've never spoken with the attorney about your bill, but they assert it that way. And what they're hoping, because you'll see on a lot of the checks, it writes payment in full or as an accord and satisfaction. Usually it's full and final satisfaction. What they're trying to get you to do is you or your staff, or maybe you've got an automatic deposit in your bank account to deposit the check. And when it says that, that means you're done. That's all you get. What I'm trying to do is to cover you here is saying it's a partial payment. It's going to reduce the balance. It's not going to be deemed that. But realize if you do, the attorney will probably still assert it. They may even still win. This is no guarantee of protection, but it gives you some leverage to hold on. If you accidentally deposited something your staff didn't know you had not agreed to at the time. So just be careful. Let's get into an area that I see growing more and more, and one of the biggest problems in this whole area of personal injury. And that's MedPay for us in California, PIP in other states. PIP, if you're not familiar, is far more expensive than MedPay. You can get childcare, all kinds of great stuff out of PIP, but it's more expensive. MedPay is very inexpensive, and that's covering for medical expenses. They're all designed to pay you promptly. That's why you pay as the patient, the insurance or the insurance company, to have that coverage so that you can get quick healthcare treatment and that provider is paid promptly to encourage them to treat you quickly when you get injured. Wonderful. That's not how it works in PI. Attorneys want to take that MedPay, even though it's issued on your bill when you submit it to the MedPay insurer, and that EOB gets issued, that insurer sends it to who? To you? No. Most of the time, they send it to the patient's attorney. Why? Because the insurance, as everybody, is worried about one person, the patient. The MedPay insurer is the patient's insurer. They can assert bad faith, which are the two words that no insurer wants to hear, because that can really expose them for a lot of money. So they figure, I'll be safe. I send it to the attorney. Let the attorney worry about it. So what do the attorneys want to do when they get it? First, they want to hold it to the end of the case. Horrible technique. Most MedPay is reimbursable. So at the end of the case, the MedPay insurer looks and say, okay, what's happened? Do I want to get reimbursed? Well, if that money's still sitting there, of course they want to get reimbursed. If they paid it out and it's not sitting in their trust account and it didn't go to the patient, Almost every time it's going to be waived in full or they'll want pennies on the dollar. It's the first mistake that attorneys make. The second and bigger one is that attorneys often take attorney fees out of MedPay and even PIP turnovers. That is really bad stuff. They literally are taking money right out of their own client's pocket, because who's going to make up that payment, especially on the MedPay when it's on your bill? The patient. Now is to pay what the attorney took when the attorney has nothing to do with it. So this provision, really important, is here to address that, to immediately turn it over, no reduction of attorney's fees. And one thing that more and more attorneys are doing now, they're putting in their agreement with their contingency fee with their client a provision saying they have a right to all the MedPay. The patient doesn't know any better. They don't know that they shouldn't be giving that. But this includes a revocation of that right. The thing which I counsel and advocate wherever I speak around the state of California or talk on webinars around the country, it's full transparency. Everything works better if people simply give full disclosure. You're going to be more cooperative. The good attorneys give full disclosure. The good providers give full disclosure, including about their bills. That's how people make really good and sound and wise decisions. You'll find if you follow that path, you'll always follow on the right side of ethics. So here in this provision, it talks about the attorney shall provide the status updates. How many of you fight to just find out what's happening in a case? I put it here. They're agreeing to do that, and they need to do that. Some states like California, they actually are more required to do that with changes in ethics rules, but let's be clear in a contract. And of course, that you want to be promptly advised when proceeds are in fact received. Now it's time to get paid. You want to know when that clock starts running, as opposed to them taking their time. But the biggest thing I want to show you here is the bottom part, not the very bottom where I put the comments, but the part that I highlighted. You should cut and paste this. And even when someone asks for you to take a reduction, you should be giving back to them saying, here's the information I need for you to do my due diligence to consider whether or not and how much of a lien reduction I'm going to give you. When they give this all to you, you're now going to see, are they asking you to take a huge cut, maybe get paid only 20% on your bill, but they're taking full attorney's fees? Are you seeing that their cost might be only $400, $600, $800, which means, hey, this didn't go very far in litigation, and yet they're still not reducing their fees to help out the same client they're asking you to help out when they're on contingency fee? And when you're a chiropractor, you want to look at the disbursement listing, because what they want to do, are they doing pro rata the same discount to everybody? So they're literally assigning you the same discount to a single visit MRI that would take you 15 visits to do? Hogwash. Don't do it. You'll see if they're doing the old 1/3, 1/3, 1/3 pro rata rule. 1/3 to the attorney, 1/3 to the patient, and 1/3 to split among all the lien holders. You're not required to do that in most all states, certainly not in California. This is going to help to get that out. And if they ever assert that it's confidential, well, in California it's not, because we actually have a attorney ethical code that requires them to give an accounting in writing. But you can say, okay, you say it's confidential. Well, I have no obligation to reduce my lien. So if you give me this information, I'll consider it. If not, you can keep it all confidential, but pay me my full lien. Think about that as you go about handling your reduction requests going forward. Now, circumstances change. One of the things I wanted to cover in the revisions I did is a lot of patients at some point may drop the attorney dropped the patient. Or how about this? How many times you find that they have an attorney, but they went to small claims in which they're going to get very little on their bill, and the attorney is still taking a percentage out of that. And that's not why you took it on lien. You thought this attorney was going to represent them and really go for it. And if not get paid fairly, they take it to trial. So at least what this is simply giving you is the ability, if that occurs, it is in fact a breach, you can decide. Do you want to now assert it as a breach and go forward to demand payment and even file a small claim yourself, or wait? Simply giving you options. This one, it's going to work a little bit both ways. So this one is to really read carefully later on a little bit more. this back on full transparency, patients have a choice. That choice includes going to you. So the more transparent you are about your fees, certainly if that attorney has used you many times, they know what your fees. So they know when they send you a patient, they've made a choice. But in the end, I'm really a big advocate for providers at the first visit having and providing a copy of what are your fees for the various codes. But at least I'm a big advocate of sending monthly bills during treatment to not only the attorney, to the patient. So everybody sees, and they have an opportunity to even object if they've got a problem. So what this paragraph is going to is they've had a chance to do a choice. They believe your fees are reasonable. They've been able to compare rates from other providers. They've chosen you, because we all know down the road, they're going to want to assert you treat too long and you charge too much. This is going to help you there. So when attorneys take a long time to resolve a matter, how are you protected? One method is interest. Because while a case may take 4 years to get resolved or longer, interest can help to make up with that for that additional time you are spending following up on a case. Plus, if someone wants to now show that they're also not playing fair with you, now you've got some additional leverage to say, why did I wait on this guy? Assert the interest. Now your lien is larger. That doesn't mean you have to get paid interest. You can choose to waive that. But this is allowing you that opportunity, including default interest and even a monthly administrative fee, because you should be taking and your staff on top of things as it goes along. So again, it's giving you options. It's giving you more protections. And let me say something. I have providers that have literally used my liens more than 1,000 times on patients. And I asked one the other day, he said, in 1,000 times, Michael, I've had only 4 people mark on it at all. All those were fine. And not once has it not worked. Now, that's funny, the next day he actually had an attorney that then he had a problem with, but that highlighted this was an attorney he didn't want. It red flagged the fact this was going to be a problem attorney. So a lot of law firms don't even read, they just sign. Even when they read, none of this is against the law. In fact, a lot of these provisions are standard contractual provisions that they themselves sign when they do everyday business agreements, like interest. We all sign that. We'll all sign with attorney's fees. That's part of normal contractual protections. You should have it too. Speaking of the devil, there's the reasonable attorney's fees if somehow, you have to fight. Why is that really important when you're dealing with an attorney? It's not so much for the attorney. The leverage of attorney's fees, the fact that the actions of the attorney may have increased the financial risk to their client, your patient. When they do that, that actually gives your patient a possible opportunity to even go against their own attorney. You would be surprised at how many attorneys really don't care so much about your patient, their own clients. It's more with them, what's in it for me. And they go to take advantage of them in the process. You have a chance to stand up for your own patients when you stand up for your bill, and the right also for the patients. And this is a way that you can help your patient, because if they're getting abused, you can help them have additional rights. Something that I find is very important that I highly recommend is, now, very rarely are you going to ever have to go to litigation on a bill. It happens sometimes. And when it does, you want to be prepared. But even more so, you want the leverage of, if it goes to litigation, that it's to your advantage. You want it in your home court. You want it in the county that you're where. In California, my goodness, we have attorneys that have clients throughout the state. They're in one area, but their patient and the provider is in the other part of the state. So if the fact that they've got to come down to you to litigate a matter, they're going to be a lot less inclined. So utilize this provision to help you. You may have somewhere you've got out-of-state attorneys, even though you're in out-of-state cases, but you're treating the patient in your state. You want to make sure that the law of your state is controlling your bill. You want to make sure there's a battle, it's back in your home court. And then some of the normal thing you'll see again in most contracts, if someone's going to modify something, then it's got to be initialed by you, okay? Or when they want to scratch out all these things, You may have a staffer that doesn't even see all the scratch outs and files it away. I wanted to give some kind of a protection when you get surprised. I can't tell you the number of times I have a client that says, oh, they never mark up my lien. And the first matter they send to me, sure enough, there it was, and they missed it. This will give you some ability to counter that, as opposed to you simply saying, we never saw this. And then one of the other final items is, time is of the essence and best efforts is required for all performances under this agreement. Promptness matters. There's so much delay that goes on in you being paid, and time is money. Time means you put more costs into it. Just the lost value of time. Your lien, say at $3,000 4 years ago, is no longer worth 4 years later $3,000. The time value of money is meant less. So you certainly want to at least put the onus, once they have to act, they do in a prompt fashion. And that's being reasonable. There's nothing that they should not be doing with this, but it gives you more leverage. How about the end of the document? Why would I put on here about patient signing and attorney signing? I guarantee you, if I pull out your lien agreements, you're going to have the patient's name and you have the scribble by the attorney's signature, by the attorney part. You will have no idea who signed it, what firm they're in. No one else can tell. So what this 2-page agreement in particular does, the law firm name, who's the handling attorney, what's the signature, okay, date sign. You want the email address. Heck, you want the email address of your patient, because when they move and they're gone 4 years later, you want to be able to find them, and more likely you'll find them with an email than an address. So don't discount the fact of filling out all those blanks. It matters later. Don't just take the scribble. Find out who signed it. Make sure it's all there. Do your paperwork. This contract is the foundation of PI, so do it right. And then one of the things I have is for the attorney, or for the provider, to sign at the end. Now, you don't have to. It's still bound, but I recommend it. It's on my lien. And the reason is I really want this to be an actual physical full contract. And I want you to sign last, because if you sign last, when they try to pull the funny things of changing wording, adding an addendum saying we only pay out 1/3 of the proceeds, or a stamp, you're going to see it. Now you can say and send back to them, I reject that, not following it. And remember, you have the ability and the choice to see a patient, to see them more, to not. That patient has a choice. You've got to decide on how you're going to run your business, because you're not there as a charitable institution. You're there for profit. So before we jump to a Q&A, I want to give you the top 10 takeaways here. And again, all of this, the presentation, you can get from Christy. You can email me. Happy to send to you. Happy to answer any questions you've got later on or on a particular instance. I and my company are here to help. But those 10 takeaways are: a lien is a contract to protect you and your patient. Protecting your patient, especially on MedPay, where attorneys aren't doing things the right way. Understand the terms of your lien and what it states. You're doing that today. You're here. You know more, believe it or not, today coming out of this than 99% of your brethren. 3, you are entitled to properly and timely pay regardless of the outcome of the case. Never forget that. Know your state laws. Lien law, attorney ethics rules. That's something you're going to have. The portal's going to help you, especially the expanded portal we come out later. We're going to cover the laws of all 50 states. But in the end, you know your own laws. Don't be afraid to assert them. 5, the patient's current attorney signing the lien is critical. When they switch attorneys, make the new attorney sign it. And even a letter of protection state. Don't accept a letter of protection. I'm telling you, you see that, you get them to sign your lien and have that contract. A letter of protection is a letter by the attorney, which isn't going to say much. Your lien is there to protect you, and that's the basis upon which you're going to do business. Make them also, or instead, even better, sign your lien. And if the new attorney doesn't sign it, declare a lien breach. Let the patient know you're not going to wait to be paid if the current attorney who's supposed to protect your money isn't going to sign it. And believe it, that first phone call is going to be to the attorney saying, sign the lien, and they will. Next, get rid of bad lien forms. So many of yours are bad. When you compare what we've gone over with what you're using, your jaw should go down, because you are needing protection leverage and enforcement, which most of you are not having. So get our agreement. It's on the portal. 8 is no shirt, no shoes, no dice. Who recognizes that? Fast Times at Ridgemont High. But you can refuse service to anyone. Again, you're a for-profit business. And I want to say again, you can always reduce or waive any term. Cooperate. Do what's right for your business, for your patient, the attorney, but you stay in control, and this is how you do it, because it's about doing business better in personal injury. So with that, I'm going to stop the sharing, and then Christy, you can jump back on, and we will go to question and answer.
So the first question that we have is, how do you handle when the attorney wants you to use the patient's health insurance after the patient is done with treatment?
Yep, great question. That's one of the tricks they try to pull. Obviously, first your response back is, you had the choice when you started treatment. Now, a lot of offices don't even take health insurance. But also, why would it, and you could go back to them, why would the patient ever want insurance? They're paying co-pays. They may have a really high deductible, all coming out of their pocket when the other person caused the accident. But I've got a more soundproof way to do it. One of the forms you'll find in the portal is actually a directive to not bill health insurance, which all of my clients have their patients sign at the first visit. So when the attorney later sends that, my clients simply say, well, your client told me not to. And MedPay, by the way, is not health insurance. So that's done as a trick. They shouldn't. There was a choice. Don't let that fall in the trap. The one reason where they might want you to do that later, that is a little more legitimate, is in MedPay, there's something called excess MedPay. To get the right to excess MedPay is, first, that's based upon a denial of health insurance in which the MedPay kicks in. Personally, you should never submit and do it. Say, no, I'm not going to submit, because if they write down your bill, you're stuck with that. And sometimes it's a game. So hopefully I covered and answered that question.
Our next question is, let's see, our office is located at the state line of 2 states. If lien laws are different for each state, do we need to abide by the laws in which the accident occurred, or by the state in which our office is located?
Beautiful question. We have it in California. It's called Lake Tahoe. Covers especially both sides in 2 states right there. That's why I said, if you look in the lien agreement, that venue provision is so important, because the litigation is wherever the litigation is venued. You can't control that. What your question is, how do I control about me getting paid? Now, the division of settlement proceeds is going to go by whatever state law where that lawsuit is venued. You have no control over that. But there's 2 different things. The settlement and how that's determined is handled by the attorney. Your lien is something completely different. You're by contract law. So when yours says, in California, we say California law provides, and it's saying venue is over whatever my county is. That means that's where it's going to control from my bill. So that's how you should do it. You'll have it addressed by just using this lien, but if not, you could write it in your own lien and do it that way. Put your own county and for your own state laws for your lien.
Okay. When a patient signs our lien and assignment, but then an attorney sends us a letter revoking this assignment because they are now representing them, what should we do?
Well, then what I would do, first of all, is immediately declare a breach of the lien, and you send the patient a notice of the breach of the lien and why. And that demand is, Mr. Patient, you got to pay me now. I'm sorry. I was willing to wait to the end of the case. Your attorney is revoking this and doesn't want to, and I need them to protect my money since they are in receipt of those settlement funds. So I'm sorry. You know, the first call that patient makes is to their attorney saying, sign the dang lien because I am not paying them right now. And you literally can file a suit if you had to in court, small claims, is your friend for a chiropractor, to actually go and enforce it based on breach. And you don't have to wait. So they do this a lot of bluffing and brouhaha, thinking you're not going to take action, but you've got a legitimate right now to declare a breach of the lien because the trust account fiduciary, who's supposed to be in charge of your funds, has said no.
In Idaho, chiropractors were specifically left out of the medical lien law. PI lawyers and insurance companies have fought us on fixing this. We have been using an assignment of benefits form. Do you have any other comments or suggestions?
Sure. Well, first of all, the lien that I'm using is contract law. So there's lien laws that assert, but don't forget, there's contract laws. So if everybody's agreed by contract, that is going to govern that relationship. So even in Idaho, you've got a contract to fall back on, and the parties are going to be held to that generally. So I again is going to focus back to, I would use again the lien, and I would get that assignment of benefits, which you can, and record that in with your state. It's usually the Secretary of State's office. One other point with that, a number of states require you to actually record a lien. So Arizona, as an example, in order to have the right to be paid, you have to take that lien and record it with the government. So it's for public notice. So again, you know the laws of your state, know which ones require you to record, and some require you giving notice. Again, it's about transparency. The law likes it when everybody knows what's going on, everybody is on the same page. That way, when it comes at the end of the day, they have an easier time in court or to enforce those rights.
Okay. What is the best way to approach a lawyer who settled a case 3 months ago and refuses to send out a letter of reduction?
You may refuse to pay you because hopefully what your first approach should be is to get paid in full. Being paid less should be the exception based on a case-by-case basis. So you're going to look at how are they doing. When they don't do that, you simply are saying, make a demand. You've been paid. 3 months has passed, a reasonable time has passed. If I don't receive payment in full within 30 days, I'm declaring a breach of the lien agreement. And in California, that actually can trigger interest if there's no interest right in the lien. So you want to take you don't have to be super aggressive, but you just want to say, hey, if you don't, I've got to declare a breach of the lien. I've got to send the patient notice. Let me talk about that for a minute. You will find that your patients generally have no idea what's going on. The first time they know something's going wrong with your bill is when you send them one of those letters that says, hey, the lien's been breached and here's why. Here's what your attorney is doing. Attorneys don't like it when you tell them that because they try to hide what's going on. So a lot of times once you give notice, your patient will help to light the fire under the attorney's behind, especially if that person says, you're actually expecting a reduction. You want to help the patient. So again, the patient is the key. They are regardless of the outcome, and they are the fulcrum point of pressure on you, the third-party insurer, the MedPay insurer, and even their own attorney.
If you do not have a lien signed by the attorney, can you send them a letter noting that their client has signed an agreement and they have an ethical requirement per the bar rule to abide by their client's agreement? Does this have any teeth to it, especially if you add that if not followed will result in asking for a complete review of the account as part of the bar complaint?
Well, the answer is really you have little leverage. In fact, the state bar in California, for example, will not even look into that matter on your assertion of a lien violation because the attorney didn't sign the lien. You do have, though, if they've had notice of the lien, most states have a claim and a cause of action what's called conversion. Someone converts your money to someone else. So if they've notice of your entitlement and send it to a third party, you can say, you damaged me as a result. So I would say that that's why it's so important. It's more important for the attorney to sign the lien than it is for the patient. That's why you want to press that. While the matter's pending is where you've got that leverage because you can declare a breach and make the patient pay now, which the patient doesn't want to do. So there's your leverage point. After the fact, in that case, you may be left with having to sue the patient and going to small claims and pressuring them because that attorney may very well send your money to the patient, or if they've already dispersed it, I would not pursue an attorney in that fact. I generally would simply go after the patient.
Okay. Let's see. We have a lot of attorneys who refuse to sign a lien.
Okay. They refuse to sign a lien, and again, then you have the option. It's like that: no shirt, no shoes, no dice. You let your patient know. Either you have your attorney sign the lien, or you're going to need a new attorney, or you're going to need a new chiropractor. So you've got to make that decision. I can only tell you if they're not refusing to sign your lien, that is red flagging an ethical problem, or the fact that they have an intent, I should say, an intent to take advantage of you. Why would you want that business? When in doing business better in personal injury, I talk a lot about it doesn't matter what you get paid at the end of the day and how much it is you keep in your pocket. And you'll see that in various webinars and things I do. Your net profit is what matters. So not all patients are the same. Not all attorneys are the same. I've got a Wine with Mike session coming up the 16th of this month where we talk about the good, the bad, and the ugly attorneys. They differ. So do your patients. So you've got to treat them differently. So what these guys do, that it's highlighting to you. You've got a decision to make. Make that decision what's best for your business. Oh, and the more likelihood where that happens is going to be within the out-of-area attorneys. If someone's local to you, it's more likely that's not the one you're having the problem with. It's more likely it's someone that's far away. You're not sending them any referrals. This is probably their only patient they're going to have in your area. So they don't care. So that's where you've got to be more aggressive with that kind of a person.
Where can we see the MedPay and PIP proceeds in a case?
Ooh, great question. Talk about this a lot. Got to listen to the other thing Christy has in her library, the ethics of personal injury, because I go in there in more detail. Every PI patient, you should be asking for one additional document when they come into your office. Give me a copy of your proof of insurance coverage. In it, it's going to show if it's MedPay or PIP, the amount. It's going to have whether there's uninsured motorists and underinsured motorists and the amount. Those both are important. If you see MedPay, I don't care if the attorney says don't go after that reimbursable MedPay, you go after it as fast as possible. It's for the patient's best interest and yours. An attorney who says don't go after reimbursable MedPay is harming their own client, in my opinion. The next thing is the underinsured motorist and uninsured motorist. In California, we have a $15,000 minimum insurance requirement. So if you see UIM is at least 3060 or higher, you know there's potentially more money at the end of the case. And you also know if the attorney's not telling you they've got that. So you'll know in advance if there's money. Now, what happens if the patient doesn't give it to you? The dog ate my homework. In California, we have something called Prop 213. If the patient is the driver and didn't have minimal insurance requirements that they paid for, they get no pain and suffering. That cuts the heart out of the patient's case. All they can get is medical expenses back, and the attorney first gets their fees out of it, so no way can you get paid in full. So that could be a red flag that a patient has a problem they're not telling you of. So that document's really important in PI. I encourage everybody to get it in every case, and just as a side benefit for you all of you should be making a call to your insurance agent, yourself, and tell all your staff and ask them, how much will it cost me to bump up my MedPay and my UIM coverage to the next level? In fact, what will it cost to go all the way to the highest? You will be shocked at how little it costs to increase your coverage, and they don't tell you about that. That may not help you on this matter. It sure will help your patient on a later one. It'll help you and your family. You'll be shocked at how little it covers and what that means. I'm at 100,000 MedPay and the maximum coverage because at least I know if my family is in my car and I got an uninsured driver, at least I know I can get people taken care of. And it didn't cost me much at all.
Can I bring a new lien, mine are not signed by the attorney, when care is already on the way or completed, but litigation has not started?
I'm sorry, read the question again. A new lien?
They're wanting to, I guess, do a new lien, even though care is already started or almost complete, but litigation hasn't started.
Well, if you had a lien signed before, I'd say no one's, and it's unlikely it's going to get agreed to, but they've already signed. I would say if you don't have one, that's okay to ask later. In the end, it's still pending. You have an automatic lien right. Okay. Like I say, if I told you to mow my lawn for $20 and you mowed it, I'd owe you $20. I have a contract. The patient got the services. They owe the money. So if they want to say, no, I'm not going to sign it, then you're simply going to say that I need to get paid now. And you're going to go back to declaring a breach and go back in the end. You have to bring an action against the patient, and small claims is your friend. The patient won't want that. He or she will want the lien signed.
What can I tell patients who do not want to use their PIP or MedPay policy because they are afraid of premium increases?
They're being lied to. It's against the law to increase MedPay. You take advantage of it, cannot increase your policy. It doesn't. It's there by law. Think about it, a little common sense. That law is there to protect consumers, and no way do states allow consumers to get messed with. So they're being told improperly. The attorneys like to get it, take the money, and if they're being told by that attorney, oh my goodness, it's just one of those really bad things I see out there, and it's unfortunate. So, you know what? All they've got to do, tell you, just simply call your insurance adjuster, your own agent, and your own agent will confirm with you your rates cannot go up.
Is it better to complain to the state Supreme Court Ethics Division or the bar when you have a complaint with an attorney?
Well, I'd say it's always better to go first to the bar. That's the licensing body. There's in California, it's great. We got new laws that got passed that brought in a lot of the American Bar Association, the national guidelines in California in November of 2018. And the state bar literally added specific provisions for lien holders and mostly for medical lien holders. That was in November of 2018. So we have great help. So I would use your bar, but most bars or anybody's not going to help you much if you don't have the attorney signing that lien. You're really going to be shooting with blanks. So I just really would encourage you. That's the focal point, is the signed lien. Now, don't just run and just file state bar complaints against everybody. I don't think that's good business. I think that you should try to work with attorneys. I say if they're doing things unethically, then that's different, because I think we all should hold people to ethical standards. If they've lied, you'll see cases where another golden document to get from a patient is a copy of what the attorney sent to them about the end of the case, with the proceeds disbursement, the settlement, the attorney's fees, costs, the liens, net to client. If you get that and compare to what the attorney sent you, you're going to find a number of times they're different. That's how you have to sometimes find the lack of ethics that are out there. So that's what I would say.
Could the assignment of benefits be combined with the lien, or do they have to be separate documents?
No, my lien, in fact, has an assignment of benefits, it says in it. However, the assignment of benefits I've written out is a multi-page document that is the most thorough assignment of benefits I think that has been written, certainly in this area. And when I do the expanded portal, it'll be in there. It's not in the free portal right now. But I would encourage anybody who doesn't have an attorney, where it's only the patient, to always get the patient signing that expanded document, and actually even to record it as a UCC1 filing, Uniform Commercial Code, at least in California. So I would encourage you. Or if it's a really bad guy, somebody you've never worked with before, you can consider it. It's adding more layers. Do you want to do that? That's your choice, but those protections are there.
What states are your services available?
Well, the portal is going to help everybody. Right now, you can go in there and you can have your staff take as a free 30-minute course. There's resources. I've got an audit spreadsheet. One of the things I find that people don't do is they don't track their PI results. So I've got a spreadsheet that tracks by law firm, case, about how long it takes to get paid, how much, all the metrics you want to know. Why you think you got paid fairly by attorneys, you'll be surprised if you fill this out and have your staff keep it up, what they're doing. It also is going to make it a lot easier when you want to follow up on cases. You can follow them all at the same time. So the portal is national, but where I go to help and represent providers in medical and recovery outsource is only in California right now. I'm hoping, I think next year in 2021, to maybe go in Florida and Texas next, but that's going to be a slower roll. In the end, the portal is going to help you to do it yourself. I'm downloading my brain into that portal. That's why it's taking so long. I have too many thoughts. Small brain, lots of thoughts.
I have a problem with lots of thoughts too. So I am going to put Michael's email address in the chat box. So if you have additional questions, if you're watching this recording, you have questions that you think about, or if you're like me and you think about questions 30 minutes after our webinar is over, like, why didn't I think of that? You can reach out to him. And please visit his website for more information as well. I just want to remind y'all that next week, we are going to have Dr. Nick Silveri here, and he's going to be talking about chiropractic content marketing, the 5 things that you can do now to help you grow. And then in preparation for who knows what's going to happen with COVID in the fall, it's about the chiropractic entrepreneur framework, and it's about setting up your business for success. And that'll be the following week with Dr. Jay Greenstein. You can look at all of the upcoming webinars for the next 6 weeks on our website at ChiroHealthUSA.com/webinars. If you are interested in visiting and reviewing Michael's previous webinar that he did with us, you can actually go to the archived webinar page. I'm going to put that link in here too, and you can look it up by speaker. You find Michael's name, and it'll show you every webinar that he's ever done too. And click on the link, and you're able to review the previous webinar that he referenced in today's presentation. I encourage you to go and look at that and get as much information as you can. It might even answer some of the questions that you already have. And again, reaching out to Michael and his team is always a great idea, and they will get right back to you to answer those questions. Michael, thank you so much for being here today.
Thank you, Christy. You do such a great service for all your members. And so I hope everybody just watches all of your webinars. Thank you again, everybody.
Well, I hope so too, guys. Y'all have an amazing rest of your week. A fabulous day. And I will see you here, same time, same place next Tuesday. Bye.
Bye.